Good evening. I'm Ann Huang, Executive Director of World Arts West. My pronouns are she, her. On behalf of World Arts West and the Bay Area artists, I acknowledge that we live and work on the ancestral lands of the Ohlone, Miwok, and Pomo peoples. We recognize their significant place in the cultural and natural ecology of the region. We express gratitude that they continue to care for the land through their living cultures and traditions. We encourage our colleagues and fellow organizations to learn about and actively support the Indigenous communities in your area. Tonight, we welcome you to Equitable Contracts, the Basics, with Matt Dedon of Art Law Access. We want to acknowledge that this topic might be anxiety provoking, so we're bringing you this workshop with a spirit of compassion and loving kindness. This workshop is part of World Arts West Professional Development Workshop Series, where we bring you information to empower cultural artists to thrive and sustain their work. A few notes before we begin. Recording and slides will be available after the workshop. Please fill out the survey. Your feedback is very important to us. Lastly, Matt's contact will be given at the end of the workshop. This program is only possible with your support. If you like seeing this workshop tonight, please make a donation to World Arts West so we can continue bringing these programs to you. Without further ado, I'd like to introduce our first speaker, Javier Stel Fresquez.
Hello, everyone. Welcome. As Anne was saying, my name is Javier Stel Fresquez. I'm a Piru and Tigua native and mixed Chicano person that grew up in El Paso, Texas. I've been in the Bay Area for 12 years. And I am wanting to share a little bit today about my own experience as an artist and presenter, and how I've gone from understanding, being intimidated by contracts to sort of a different state of understanding what they can be. But before I do that, I actually want to invite everybody to participate in a poll that we have ready for you already on the event tab of your Hop-in screen. If you look above chat, you'll see event on the left side. If you click that, and then you click poll underneath that. So again, this is the poll in the event tab. There you can find two polls that we have already had some folks participate in. Thank you. And if you could let us know, are you an artist, organization, or presenter, or something else? That's one of the polls. And the other one is, how intimidated do you generally feel by contracts? As I'm speaking, you can go ahead and look at those and fill them in. It'll help us understand who came today and who our community is and how we can serve them. So that question about it feeling intimidated really relates to what I have tried to navigate as a presenter within the Two-Spirit community here in the Bay. I work with Native and Indigenous communities from different locations, and I have produced and curated the first Weaving Spirits Festival, the first festival of Two-Spirit performance here in the Bay. It is a real honor and a privilege to work in intergenerational community with traditional artists, many of which are multidisciplinary, many of which who are bringing their cultural forms to the stage for the first time, or just don't have that much opportunity to work in larger stages like the one we co-presented the festival in for the first time in 2019. So as part of that co-presenting with a major theater here in San Francisco, that theater approached us, helped us write the grants, also gave us a lot of collaborative free rein to make a festival that would be good and appropriate for natives of the Bay. And with that, I wanted to make sure that our artists would be taken care of in culturally specific ways, that they could have some control over their image and over the use of their traditional forms going into the future. So one of the main things that I got to do, thankfully, is to approach the director of the theater and ask, okay, can we do this contract thing in a way that is a little bit different, that allows for a long-term, healthy, regenerating relationship with these native artists who might be taking risks just with the cultural forms and the stories that they carry. And thankfully, it was a wonderful collaboration with the theater, who was very amenable to changing the contracts that they had used for years with many artists. Probably hadn't changed them much in a decade. And with that, we could easily tell our artists, look, this place is very open to you. It's willing to shift. It's willing to transform a bit. It's willing to even let us burn sage inside the theater. That was another thing that we were able to negotiate. But that's one thing that I wanted to just share, that there are ways to go from intimidation, feeling intimidated around contracts, to feeling other more positive things. So that's my little segue to our poll that's here in the stage. If you could fill that out as well at the end of this, it'd be wonderful to see what people have to say about this last question. If you look at the tab next to the event tab on the right side of your screen, the stage tab, click stage, then beneath that, polls, then fill out that poll. That would be really wonderful. And you'll be able to see how other people are feeling who have attended, who are attending right now. Thank you so much. Chimigwech, mahalo nui. I'd like to turn it over to the programming and production manager for World Arts West, who also has been holding down the Ethnic Dance Festival for many years, Sonia Pina.
Hi, everyone. Thank you so much for being here. Thanks, Javier. As Javier was mentioning, I am Sonia Pina. I am the program and production manager here at World Arts West. I am the proud descendant of the Yoruba, Bantu, Moor, and Ashkenazi people. I'm also joining you today from the unceded territory of the Chocheño. I always want to do this, but it's Chocheño Oloni folks, and I use she, her pronouns. Today, I'm here to talk with you all about performance versus engagement. So there's been some conversation, definitely in this last year, with all the cancellations due to COVID, around what do you do when everything is canceled and you as an artist have no promised income, or an agent, or anyone around the arts industry. I, as a technician, suffered that myself. All of this expectation that I have of regular gigs, all of that went away. One of the first starting points in negotiating contracts to me is these terms right here: performance versus engagement. So when you are engaging in a performance, this usually is just that, right? Like the part where you show up, you do what you do, and then it's over. However, most of us artists really know how much more it takes than just showing up to do the performance. There's a ton of other costs associated with doing a performance, right? We rent rehearsal space, or even finding rehearsal space takes a lot of work. And we have a lot of activities around preparing for a performance. So we have transportation, we have costumes, any materials you might need. Maybe you have musicians that are part of your group, but a lot of folks need to hire a musician. So all of those details, right, all of that starts accumulating into the end performance. But throughout that process is the whole engagement required for the performance. So one level of encouragement that the industry is trying to achieve is changing the contract language, morphing from performance versus engagement. So there's a few things to keep in mind, once you're advocating for yourself in that way. contracts in themselves are meant to be a transaction, right? You do this, I will do this, and then that's it. One of the things that I find personally, and one of the waves that we're trying to advocate for here at World Arts West, is to change a little bit of that mentality of, just this transaction, but that a contract is meant to be the beginning of a relationship or a clarification about your relationship. However it takes to to be in a good relationship. So in the contract, when you're trying to advocate for yourself in changing this language of performance towards engagement, there will be a list of responsibilities. There'll be the responsibilities that you have as a performer, and then there'll be the responsibilities that the presenter has. You want to make sure that you feel comfortable with what your responsibilities are and what their responsibilities are. To me, this is where the key moment is to have your engagement, the responsibilities. When you are in an engagement, you can clearly outline what your responsibilities are and create this sort of payment schedule based on the set of deliverables, right? So in a great, wonderful world, you would get money just for signing as a sign of good faith from whoever that presenter or organization is, company, whatever, right? That they're saying, we're so happy that you signed, here's a little bit of money. Try as much as possible to take away the money, that money term as a deposit, right? Don't put it as a deposit. Deposits, we know could be returned. Yeah. So we don't want that. Again, we want to be acknowledged as part of our engagement. There's another set of things that you can mention as part of your engagement that, again, will help you in advocating this different relationship. So you can create, again, these deliverables. Some examples are turning in your tech writer, turning in marketing materials, or even rehearsal visits, right? That would be something in terms of the World Arts West method for the San Francisco Ethnic Dance Festival, right? That we want to start moving towards that model, that any set of those deliverables in the season, right, in the engagement are acknowledged and are also rewarded. So we want to make sure that we're acknowledging all the work that it takes to get to that step. So my next point is that contracts vary in content. Some also look very different. I myself have had the experience of viewing contracts that just seeing them is intimidating. Maybe it has like 5-point type. That itself doesn't feel great. And sometimes the legalese language is so intense that it feels impossible to go through it. The point of today, though, is hopefully to get you to a point where there's some parts of the contract, the parts that always exist in a contract, that you feel confident approaching those. Every contract has them. They might not be clearly labeled. They might, in the spelling of it, sound different. But I promise you, they all have the same structure. And again, it's up to you to advocate for yourself and make sure that you understand. So hopefully with the tools that we're handing you today, and with your own sense of confidence to advocate for yourself, you can move towards really understanding every bit that you're signing in a contract. So with that, I want to hand it over to our expert for tonight. It's been our pleasure to work with this person. His name is Matthew Dedon. And we started engaging in work with Matt a couple months ago, and we've been blown away with his professionalism, his clear communication, and the ease for advocating for ourselves and feeling like we have an ally moving in this world. So thank you for sticking in for this portion. Thank you to Matt, and here he is.
Thank you, Sonia. That was a very kind introduction. Hi, everybody. My name is Matt Dedon. I'm one of the co-founders of a law firm called Art Law Access. It's a nonprofit, and its mission is to empower and help entertainers, artists, and entrepreneurs and other nonprofits. My contact info will be towards the end of the slide, so you can pick it up there in the recording, which is going to be provided to everybody. So a little bit of housekeeping at the very beginning. This presentation does not create an attorney-client relationship between me and any of you. Everything said in this presentation is for education purposes only. Now, I'm going to be showing you several examples of legal language. Do not use this exact same legal language in a contract. This language is for example purposes only and will need to be altered for every contract that it appears in. Okay, next slide, please. Okay, so this is the basic structure of a contract. You've got parties, recitals, definitions, operative provisions, miscellaneous, boilerplate clauses, signatures, and schedules or addendums. Okay, every contract that you're ever going to look at can be broken down into these sections. And I want to bring up points that Javier and Sonia made, is that a contract is like a collaboration or a relationship. Think of it as building something, two people building something, either if it's a house or just a relationship together. If one person is not happy with the house that they're building or the relationship that they're in, then it's not a good house or relationship, and it needs to be changed. With that being said, understanding how this works will kind of help you change that if you're not happy with it. Okay, first up, you've got parties. In the case of a contract for the service of an artist, the parties would be the artist and the company that's hiring them. The parties are usually followed by the recitals. This section provides the background to the agreement, usually what both parties want out of the deal. It's like a small summary. Following that is the definitions. Sometimes these are at the beginning of the contract, and sometimes they're in sections of the contract when they are first used, just kind of sprinkled throughout. In the definitions, the contract will explain what a term means, and then only use that defined term throughout the rest of the contract, usually to save space. For example, a company hires a musician to perform at a festival. In the definitions, it would define the festival itself using language like, for the purposes of this contract, EDP refers to the Electric Dance Party. For the remainder of the contract, it would only use the term EDP instead of using the full name of the festival. That's what a defined term is. The meat of the contract are the operative provisions. This makes up most of the contract and spells out the rights and responsibilities of each party and the actions that both parties must take. This section contains the parties' warranties and conditions. Now, a warranty is where a party promises that a fact is true and reliable. For example, an artist promises that they are the creator of a painting and it was not copied from somebody else. A condition is a duty that a party must perform under the contract. Using the artist in the previous example, a condition would be that the artist must create a portrait for the buyer. Miscellaneous or boilerplate clauses are located towards the end of the contract. These are also called boilerplate because it is standard language that appears in most contracts. It doesn't change very much in between contracts. This is where you'll find the choice of law provision, which sets out which state's law controls the contract, and the force majeure entire agreement and severability clauses, which we'll learn about in a few minutes. That's common language. At the end of the contract are the parties' signatures and the date that was signed. A contract is usually not enforceable, unless it is signed. Occasionally, there are schedules or addendums attached to a contract. A schedule may list something that is included in the contract, but have more detail. For example, a price list or a payment schedule. An addendum is an attachment to the initial contract that details additions to be included in the contract. Addendums usually contain items that were not decided when the main contract was being drafted, such as the specific tasks someone will have to do in performing their role under the contract. Although, I want to be clear, when you are given a contract that mentions an addendum, always review the addendum as well. It's just, if somebody refuses to give you the addendum, then they're hiding something. Okay, next slide, please. Okay, here's common terms in contracts. These are the common terms that appear in almost all contracts. I'll give an example of how the terms are used in the contract, and then I'll explain what they mean. As a reminder, do not use the exact language that you will see in these provisions in your own contracts. Most language needs to be adjusted to fit the contract in which it is used. The terms are work for hire, representations and warranties, force majeure, indemnification, arbitration, the entire agreement, and severability. Next slide, please. First up is work for hire. So in this example, any artistic works, i.e. photographs, video footage, paintings, etc., produced under this agreement shall be deemed Work for hire, as that term is defined by the Copyright Act of the United States, Title 17, United States Code. So what this small but very important passage means is that if this language is in a contract, the employer, not the employee, will be considered the author of any works produced by the employee during the term of his or her employment. The employee will not have any rights to any work they produce. This does not apply to works created by the employee on their own time. So when you get a contract, especially this especially is important towards artists, those creating something for somebody else. When you get a contract, you need to look and see, is the work for hire language in there? If it's not, that means that you are going to own the copyright to whatever is produced. If it is in there, and if you're not expecting it, you need to bring this up. If it's in there and you are expecting it, fine. You've been hired to do a job, and you will get paid for doing it. Okay, next slide, please. Representations and warranties. So the example is, artist represents and warrants that the project is the sole work of the artist and does not infringe the intellectual property rights of any third parties. Okay, what this means. A representation is a statement of fact. A warranty is a promise that a fact will not change. This language is commonly used in artist contracts to guarantee that a work of art is original and not taken without permission. This is very frequent, and almost every contract that crosses my desk is because we mainly deal with artist contracts and entertainers. This language is going to be in there. They have to know that the artist, the person that they hired, is not taking the work from somewhere else, because then they can be liable for copyright infringement. And when I say them, I mean the person hiring the artist to do the work can get sued instead of the artist, and they don't want that to happen. When that comes up, there's something called indemnification that'll kick in, and we'll explain that a little later in the presentation. But it's very important that this language is in a contract because it protects parties. And it's also very important that the work that's done is original. Otherwise, everybody can get in trouble, and it can be very expensive. Okay, next slide, please. Force majeure. This is a very neat sounding phrase, very Latin-y. So, example, no party under this agreement shall be responsible or liable for any failure or delay in the performance of its obligations hereunder by reason of an act of God, fire, flood, war, public disaster, strikes or labor difficulties, governmental enactment, regulation, or order, or any other cause beyond its control. This is something that came up quite a bit over 2020 and early 2021. What this means is that if any of the events listed in this paragraph occur, then the affected parties are relieved from performing their duties under the contract for the duration of the event. Now, this really came into play over the last year when the pandemic hit, as global pandemic or just pandemic or plague are often listed in a force majeure passage. There's maybe a few listeners out there that were affected in some way when one of these contracts force majeure clauses came up. This was commonly a very little. It wasn't used very much. It's in all contracts. It's very, very boilerplate language, but it almost never comes up until last year when one of these events, these horrific events, actually happened. And now it's something that is being examined much more closely, and in the years going forward will probably be coming up more and more often. So get familiar with this language. It's one of those, you don't think of it until you need it. So you really need it in every contract. Next slide, please. Indemnification. So here's the example language. To the extent legally permissible, artist shall indemnify, hold harmless, and defend the other party and the party's agents, affiliates, and employees against any and all losses, damages, liabilities, deficiencies, claims, actions, judgments arising from or related to the artist's own intentional or grossly negligent acts, omissions, or performance of the artist's obligations hereunder. Very important passage, very important that you understand what it means. This clause contractually obligates one party to a contract to compensate another party for losses or damages that have occurred or could occur in the future. So what does that mean? So let's take that representations and warranties examples that I gave earlier. Let's say an artist, me, is hired to write a book for just somebody who wants to do their memoirs, or somebody who has a great idea but they're not a great writer, so they hire a ghostwriter who needs to write a book. So I start typing it out, and then I run into a roadblock, writer's block, about halfway through, and so I start looking for inspiration, and I find another awesome book that's already been published and written, and I just crib entire sections from this book and plop it in mind. And then a little later on, I think, all right, let me just tweak the language a little bit and see if that maybe gets me out of it. That's bad, because then whoever wrote that book that's already been published is going to notice. It could be, just a few days later, could be a year or two later, but it always gets discovered when somebody else copies from somebody else. And at that point, they are not going to sue me. No, my name is not on the book. They're going to sue the person that hired me to write the book. And then that person, after they get sued, is going to be liable for some sort of damages. Then that person is going to look at their contract, see the indemnification section that's in there, and then turn to the person who wrote the book, me, and say, hey, you gave me something that belonged to somebody else, and I got sued for it, and now I owe them all this money. You are going to have to pay me back for all the money that I'm going to have to pay to this other guy who sued me. That's what indemnification means. It's almost always in a contract, and it's very important that it's in there. Again, it's one of those things that you don't need it until you really do, but when you do need it, you really need it. As judgments, especially in IP cases, range from the very small to the very large. So it's very, very important that it's in there. So in case you're hiring somebody, that make sure that you're protected in case they do something that's bad. Okay, next slide, please. Arbitration. So in the event a dispute shall arise between the parties to this agreement, it is hereby agreed that the dispute shall be referred to United States Arbitration and Mediation for arbitration in accordance with United States Arbitration and Mediation rules of arbitration. The arbitrator's decision shall be final and binding, and judgment may be entered thereon. Okay, what does this mean? Arbitration is an out-of-court proceeding in which a neutral third party called an arbitrator hears evidence and then makes a binding decision. Usually the parties give up their rights to sue in court if this provision is in a contract. Arbitration is faster and usually a bit less expensive than a court proceeding, which is why a lot of places like to use it. It also means that usually you can break up a class action, which is a big award, which people want to avoid giving those out. So this is basically substituting a lawsuit in a court to instead it's basically like a smaller court, and instead of a jury, there's much less people deciding who wins and who loses and what exactly people get if they win or lose. So just think of it as a kind of like a substitution for court. There's benefits and drawbacks for arbitration. Usually when it comes to actually being able to sue in court, the damages can be higher, the cost can also be higher, so that's a drawback. Arbitration, again, it moves faster. Another downside to arbitration is that there's a bit more law when it comes to suing in court that lawyers can use, but then again, you might not want that. So there's the arbitration example. So just keep an eye out for when this pops up in an agreement and decide whether or not you really want to give up your rights to sue in court. Okay, next slide, please. The entire agreement. This agreement constitutes the entire agreement between the parties with respect to the subject matter hereof and supersedes all other prior agreements and understandings, both written and oral, between the parties with respect to the subject matter hereof. Okay, so this is also called a merger clause. This language means that the signed contract is the complete agreement between the parties, and any other promises, any other oral agreements that might have occurred between the parties before this particular contract was signed do not apply. So let's say two parties meet and one promises the other, just orally, says, I'm going to give you $1 million if you paint this painting. And then later on down the line, they formalize it by having a signed contract. And that contract says, I'm going to pay you $10,000 for this painting. And this is the entire agreement between the parties. Well, that promise for $1 million is gone. He's going to give $10,000 for this painting. So when you see this in a contract, and you will, it's in almost every contract, it's very boilerplate, make sure that everything else in the contract really lines up with your discussions that you had between yourself and the other parties beforehand. Because if there's something in the contract that wasn't in those earlier discussions, or if there's something in the contract, or there's something that you had earlier that's not in the contract, don't sign it. You need to give it back and say, hang on, you've missed something or you've left something out. Let's put that in the contract. Usually they say, oh, shoot, sorry, let me put that in. If they refuse, well, they're hiding something else, and that's a bad deal. Okay, so that's what the entire agreement means. Next slide, please. Severability. It sounds like chopping something, and that's pretty much what it happens. So, example. In the event any provision or part of this agreement is found to be invalid or unenforceable, only that particular provision or part so found and not the entire agreement will be inoperative. What does this mean? If part of a contract is invalidated by a court or law, then only that part of the contract is void and the rest of the contract remains in effect. A good example of this are non-compete clauses. These are void in California. If they're in a contract, then only that part of the contract with a non-compete clause is void. The rest of the contract remains effective. If any of you don't know what non-compete means, basically it means when you sign up to do it, when you get contracted to do a job, and if there's something in the contract that says you can't look for another job while you're with us, that's void, especially in California. Not necessarily in other states, but definitely in California, because then that kind of restricts how people can develop their professional lives and their skills. And California just doesn't want that. So severability, it cuts if a part of the contract gets nixed, only that part goes out and not the entire contract. Next slide, please. Okay, on this slide, I've just put some good practices to keep in mind just when dealing with contracts. These are basics that you should always remember, and you should not be afraid to press if it comes to it. So, good practices. I've divided this into always and nevers. Always get an agreement in writing. Yes, there are such things as oral contracts, but good luck enforcing those in court. Because when you go to court, you need to show proof that there's an agreement, and if there's only two people, then it's just he said or she said or they said. You're not able to prove it, in which case probably nothing's going to get done. So if you need to get an agreement, get it in writing. Always read what you are going to sign. Don't just sign it and assume everything's okay. Even if you meet somebody that seems very friendly, that could just be a facade to get you to sign something. So always read what you're going to sign. And this leads into my next point. Always talk to an attorney or a contract expert if you do not understand a contract or part of a contract. If there's something in there that doesn't make sense, even if it's just a small thing, or just the entire thing, there's something off about it, there's something you don't like, but you're not sure what to do about it, please talk to somebody. It doesn't have to be an attorney. They're just contract experts. If you know somebody who's good at contracts, go to them first. But then again, if they don't understand it either, talk to an attorney. This is their job to explain these things. Usually there are attorneys out there that have fees that aren't too big. So you have options. Let me put it that way. You have options, but please talk to somebody before you sign something that you don't understand, because otherwise you can get in real trouble. Now to the nevers. Never download a contract from the internet and use it as is. It will need to be updated to your specific situation. This kind of goes towards services like LegalZoom, Rocket Lawyer. Those are great services. They can get you a contract, but they can't be manipulated too much. It's pretty much a form that you get. It always will need to be tweaked to your specific situation. So always make sure you read it and then you update it to what it needs to be. So don't just take it as is. Never assume that a contract is fair. This goes back to always read what you're going to sign. Read it. Don't assume that the other person is on your side, because the contract, some people think of it as a competition. I think that's a bad way of looking at it. I think a collaboration is a better way to think of it, because if you build a strong collaboration, it's something that's going to last and it's going to be very profitable for both of you going forward. If you think of it as a competition, then there's always going to be a winner and a loser, and there's always going to be sore feelings, and this can frequently lead to litigation, a lawsuit, because somebody's not happy. Even if there's a contract, lawyers can take that to court and then argue about it for years, and then the only winners are going to be the lawyers who are going to be collecting fees throughout the entire process. Never assume a contract is fair. Make sure you read it. Make sure that you are happy with it. And if not, you need to push back. Never assume that a contract cannot be negotiated. This kind of goes back to what I said at the very beginning. If two people are building a house or two people are in a relationship and they're not happy with it, then it's not a good house or a relationship, and you need to work on it. This doesn't mean that the entire thing's bad. It just means that you need to push back in the parts that you're not happy about and try to get it to a point where you are happy about it. So I think examples that artists have had to deal with, for example, if you're a performer and there's no dressing rooms in the contract, you should ask for dressing rooms. And if the other side balks at that, no, that's ridiculous. You need dressing rooms. That's kind of just good common sense. So never assume that there's something in there that cannot be negotiated. That's what a contract is. You're building a deal. Everything can usually be negotiated. Okay, so then to the next slide. I think we're almost done. Next slide, please. All right. So the end. Ann and I are going to be answering your questions in the session immediately following this presentation. And on the very next slide, if you go to the next slide, please, you're going to see my contact information. So if you do have any questions about this or want to get in touch, that's where I am. That's where I am. There's my email address and my phone number, and that's our website if you want to find out more about us. So if you have any questions or anything you just want to look us up, go ahead and take a look there. And I will see all of you, or those of you who are interested, in the next session. See you later.
Yeah. Oh my God, so much stuff. I know dealing with contracts is usually a crazy thing, right?
Well, thank you, everyone. I took lots and lots and lots of notes from all of you. So we're gonna segue into our part 2 now, where we will answer your questions. You can find these 2 workshop sessions by clicking on Sessions on the left-hand side of your screen. Then you'll find 2 options. One is the producer perspective, where Javier and Sonia will be. Javier, do you want to share some brief words around that?
Sure. We'll be sharing a little bit more about what we said initially and fielding any questions that you might have about how to go from being intimidated to more empowered when thinking about and doing contracts as an artist.
Alrighty. And the other session will be Consult a Lawyer, where Matt and I will be answering your legal questions directly.
All right. See everyone in the sessions. Thank you so much.
Thank you.
Thanks, Matt.
Thank you, guys.